Good afternoon, everyone. My name is Glenn Gottlieb. I'm the chair of the mediation section of the Beverly Hills Bar Association. I want to welcome everyone to this webinar on, guess what? Your online mediation is not confidential. This is being co-sponsored with our mediation section as well as the litigation section of the Beverly Hills Bar. Thank you very much to the litigation section for joining us. Everybody should have gotten an email with the program materials for the program about an hour ago. And just as a matter of housekeeping, you will receive your MCLE certificate by email also within 24 hours after the program. Our presenter today is Jeff Kichaven, a longtime friend of mine that I'll allude to in a moment. Jeff is literally one of the preeminent mediators, not just here in the Los Angeles community, but also nationally. I could give you a long list of his credentials. His CV is very impressive, as you might imagine, going from graduating with honors at Harvard Law School to the various preeminent firms here in Los Angeles that he's been associated with. First as a young pup, while I was at Gibson Dunn, he was at the Alschuler firm, and that's where we first actually ran into each other. He's been, since he became a full-time mediator in 2001, so he really was an early adopter in our field. He's been a past president of the Southern California Mediation Association. He's on the ALI. He's been heavily involved, not just in the SCMA, but also at the national level with the American Bar Association. I really respect Jeff has taken many positions on issues of the day in mediation, sometimes controversially, shall we say, but always with his own point of view, and he's been a strong proponent of that point of view and creating a dialogue within the mediation community. I want to say on a personal note that when I was contemplating going into mediation around 2005 or 2006, Jeff was personally very kind to me, and I greatly appreciated his helping me with the transition and allowing me to sit in on a couple of his mediation sessions. And, you know, if there's nothing else, as a testimony to his generosity of spirit and his being, as we say in the legal world, a mensch. So, Jeff, thank you very much for your personal courtesies over the years. We're friends and both members of the Los Angeles Athletic Club, so we've seen each other. Well, I'll leave it at that. You can imagine what happens in a locker room. With that, let's get to more substantive matters. I'm going to turn it over to Jeff. For the folks who may have questions during the program, Jeff has asked that we take the Q&A at the end of the program after he's made his presentation. We have both a Q&A function as well as a chat function that you will see at the bottom of your screen. If you do have a question, please just put that in the Q&A and not in the chat so that I don't have to monitor both of them. Sorry about that. I will be monitoring the Q&A at the end. With that, Jeff, I'm going to turn over the program to you. Thank you very much for doing this for us today.
Glenn, thank you so much for your kind words, and thanks to the Beverly Hills Bar Association for having me. Glenn, when you talked about my educational achievements, Let me just add to that, I'm also a proud graduate of Beverly Hills High School, class of 1973, and before that, Horace Mann Elementary School in Beverly Hills, class of 1969. So Beverly Hills is really home for me, and I've been a member of the Beverly Hills Bar Association for 40 years. So this really is kind of a homecoming presentation for me. I'm very proud, very happy to be here, and delighted to share some thoughts with you. I've worked with many members of the Beverly Hills Bar Association in mediations over the years, and I've always appreciated the levels of skill and ethics that Beverly Hills Bar Association members bring to the practice of law. Now, I want to talk about how we practice in mediation, how it affects not only us as mediators, but also the litigators. The litigation section is a co-sponsor here, and some ways that we can improve how we work together, how we can work better together to serve clients better. So where does our story begin today? Well, it begins almost exactly a year ago when there was a dramatic shift in all of society worldwide and everything went online. I was considering a mediation in which I would be the only person physically present in California. Everybody else would be in different states, and no two people would be in the same state. They were going to be sprinkled all over the country. And so I asked myself, what state's confidentiality or privilege law would apply to that mediation by operation of law? This question came to mind and was particularly important to me because I do not use the so-called Mediation Confidentiality Agreement, and I haven't used one for at least 15 years. Well, I started doing a little legal research, and I quickly found myself in over my head. I was studying for the first time the subject of conflict of laws. Now, I never took a conflict of laws class in law school. And as a mediator now, people give us briefs and there are hyperlinks and copies of cases attached. So I confess my legal research skills are kind of rusty. I needed help. So I called a friend in the academic world, Professor Teresa Frisbee at Loyola University Chicago School of Law. And she recruited a wonderful law student named Tyler Codina to help us with our research. And what he found was astonishing. And I want to share this in visual form with you. I don't use PowerPoint and screen share anymore. I find they often don't work right. There's glitches. So I now use a more advanced and sophisticated method of visual aids, visual communication with you. Tyler found a case called Larson versus Larson, a 10th Circuit case from the year 2017. It was a family dispute. Two siblings were in litigation against the third sibling regarding the distribution of assets from their parents' estate. The case was pending in the United States District Court for the District of Wyoming. They decided to have a mediation, but they did not do their mediation in Wyoming. They decided to go to Denver, Colorado, the next state south of Wyoming, to do their mediation. So they all got together in Denver. Colorado law is very protective of mediation confidentiality. And the parties all signed a confidentiality agreement among themselves, which specified that Colorado law applied. They signed a term sheet. They thought they had a deal at the end of the mediation, but then they couldn't agree on the final documentation. Specifically, there was a dispute as to whether one piece of property was within the scope of their proposed release. Two siblings, Arnie and Arla, said yes, and their brother Charles Larson said no, this one piece of real estate was not within the scope of the proposed release. Well, Arnie and Arla moved to enforce the term sheet in Wyoming, where the case was pending. Wyoming law regarding mediation confidentiality and privilege is very different than Colorado law. Wyoming law is not protective of mediation confidentiality at all. So in Wyoming, Arnie and Arla sought production of Charles' PowerPoint from the mediation. They claimed that Charles' PowerPoint showed that he was negotiating over the one disputed piece of real estate. The magistrate judge in Wyoming looked at this and she noted that Wyoming choice of law rules generally honor choice of law agreements, such as the Larson's Mediation Confidentiality Agreement. Unless, and here's the big unless that agreement offends the law public policy, or general interests of Wyoming citizens. Remarkably, the magistrate judge found those conditions satisfied and ordered production. I look at that and I say, wow. You talk about offending the law, public policy, general interests of Wyoming citizens? Where do you find that here? This is about as purely private a dispute as one can find, a family disputing intergenerational transfers of property among them. Where is the public policy or general welfare interest here? Well, Charles Larson and his lawyers had the same reactions, and they took the case up to the 10th Circuit. The 10th Circuit affirmed the magistrate judge did not abuse her discretion. And we say, wow, once again, protective law disregarded, confidentiality agreements disregarded. An amazing result out of Wyoming in the 10th Circuit. Now, I can read some of your minds, and I know this is not concerning you very much, because after all, you ask yourself, what is the likelihood that one of our California mediations will be tested in the courts of Wyoming? Don't get me wrong, Wyoming is a wonderful place. It's a beautiful state. It's got a lot of natural resources and physical beauty, terrific people, but not many people. It's sparsely populated. It's not a commercial center. So the likelihood, I agree, the likelihood of the confidentiality of our California mediations being tested in Wyoming is remote. But what if I were to tell you that the same thing could well happen in New York? If you do commercial cases, as I do, and even many other kinds of cases, what happens here in California might well become relevant to a later lawsuit in New York. So let's take a look at what happens in the courts of New York. The first case to which I want to draw your attention is People of the State of New York versus Pricewaterhousecoopers, an appellate division case from 2017. Many of us know that's what they call their intermediate appeal court in New York. They call it the appellate division. And what every other state calls its Supreme Court, New York calls its Court of Appeals. In any case, the PricewaterhouseCoopers lawsuit was part of the New York Attorney General's climate change litigation against Exxon and others. The New York Attorney General subpoenaed Exxon's file with PricewaterhouseCoopers, its accounting firm. The communications between them principally took place in Texas, where Exxon is headquartered. Texas has a statutory accountant-client privilege. New York does not. So the question before the New York court was, apply the law of where the communications took place, Texas, or the law of the forum where the discovery was sought, New York. Remarkably, the New York courts applied the law of the forum where the discovery was sought, New York itself, rather than the law of where the communications took place, and the law of privilege on which the communicants were presumably relying because they were all in Texas. But the New York court refused to respect the Texas privilege and ordered production. Now, to understand what makes it particularly remarkable, really remarkable, you have to get into the weeds of conflict of laws. Now, if you share a bit of the nerdy streak that I acquired at Beverly Hills High and my other educational institutions, you'll find this fascinating. So let's get into it. There are actually two restatements of conflict of laws put out by the American Law Institute. First one in 1934, the second one in 1971. The first restatement, 1934, used what it called the territoriality test. The territoriality test provides that in cases of conflicts of law regarding evidentiary privileges and confidentiality, courts were to apply the law of the forum where the discovery was sought, regardless of where the communications took place or the expectations of the parties based on where those communications took place. This rule was widely criticized. It caused a lack of predictability, encouraged forum shopping, and so forth. So in 1971, the second restatement replaced the territoriality test with the most significant relationship test. But what is the most significant relationship test? Well, under that test, courts are supposed to apply the privilege law of the state with the most significant relationship to the communications at issue. Generally, that's where the communications took place. So since 1971, plenty of New York courts have applied the most significant relationship test, applied the privilege law of the state where the communications took place, and all was well. But there are these other cases, another line of cases of which PricewaterhouseCoopers is a part, which go back to the territoriality test. New York courts do sometimes apply it. So just as New York does not have an accountant-client privilege, it has almost no statutory protection for mediation confidentiality or privilege either. New York has civil practice law and rules, section 4547, which is the analog of Federal Rule of Evidence 408. Offers and demands in settlement negotiations are inadmissible, but inadmissible solely if offered to prove liability or the absence of liability for the claim being negotiated. Settlement negotiations are admissible for other purposes. In my mind, it operates like the hearsay ban. We all know hearsay is inadmissible to prove the truth of the matter asserted, but it can be admissible for other purposes, and clever lawyers can generally figure out another purpose. So if the confidentiality of a California mediation is tested in a New York court, and the court decides to apply the territoriality first restatement approach, good luck. Even with the most significant relationship test, though, the world has become a more complicated place in the age of online mediation. Now, the Larson case, the mediation took place in Colorado. Everybody was sitting in a conference room in Denver. Exxon and PricewaterhouseCoopers, well, most of their communications took place in Texas. But where do communications take place in online mediation when people are in different states? I think a trial court will have broad discretion to apply the evidence law of any state in which a mediation participant was physically present. And remember, the trial court's decision will likely be reviewed on a very forgiving standard, abuse of discretion. So a trial court has a motivation to do justice in the case before it, to get all relevant evidence before it, to increase the possibility, the likelihood that it will indeed decide the matter correctly. So the courts will have motivations to apply the laws, the evidence laws, which give them the greatest ability to get their hands on the evidence they want and need to decide cases correctly. Predictable reliance on the California mediation statute is becoming, shall we say, a risky thing. So if the territoriality test might beat you in New York, what about private confidentiality agreements? Do they fare any better in New York than Wyoming? The answer is maybe not. The leading case here is called Hausinger versus Hausinger. It's a divorce action. The Hausingers had a mediation as part of their divorce. They reached a settlement, but Mrs. Hausinger got settler's remorse. She applied to the court to set aside the marital settlement agreement as unfair, and she subpoenaed the mediator. She thought his testimony would help her. The mediator, as you might expect, objected, invoking the parties' mediation confidentiality agreement. The appellate division in 2007 affirmed a trial court decision disregarding the mediation confidentiality agreement and ordering the mediator to testify. Caused quite a controversy in the New York mediation community. There were plenty of claims in 2007, 2008 that the sky was falling. The Uniform Mediation Act was introduced in the New York legislature, but it was not enacted and has not been enacted in New York to this day. Then in 2008, the New York Court of Appeal decided the case, and it found rather remarkably that Mr. Hausinger had in fact waived the protections of the mediation confidentiality agreement. But the Court of Appeals did not disapprove of or even mention what the appellate division had done when the appellate division found that it was not an abuse of discretion for the trial court to disregard the confidentiality agreement and order the mediator to testify. So the appellate division decision in Hausinger just kind of hangs out there. It looks like the law of New York is that it is not an abuse of discretion for a trial court to disregard a mediation confidentiality agreement. And there are more recent decisions from New York from last year, which show that this kind of commotion is continuing. And let me talk about some more recent cases. The first one is called General Electric Company versus APR Energy. There's a decision from Magistrate Judge Fox, April 29th, 2020. This was General Electric's motion to compel production of materials from a mediation in a related case in which APR participated in Illinois. General Electric was not a party to the related case and did not participate in the Illinois mediation. APR opposed the motion on the grounds, among others, of the mediation privilege in the Uniform Mediation Act, which is the law in Illinois where the mediation took place. The district court refused to apply the Illinois Uniform Mediation Act, applied New York law, and overruled the objection. There were other objections as well, attorney-client privilege and work product, and the court sustained those objections, and so the materials were not ordered produced. But the important point for us in California, who have our so-called absolute confidentiality statute, is that New York courts show a concerning ability and inclination to disregard the more protective statutes of other states. Then what happened next in New York? Well, that next case is called Accent Delight International versus Sotheby's. And that's a case from the district court, District Judge Furman, December 14th, 2020. And this is a case, the kind of case you find in New York. A high-stakes fine art fraud scheme is unraveling. And this was Accent Delight's motion to compel production of materials from a mediation in a related case between Sotheby's and one of the alleged perpetrators of this fraud scheme. The parties to the prior mediation did have a written confidentiality agreement. It was not very detailed, but apparently they had one. So District Judge Furman ruled that Sotheby's could obtain the discovery it sought, but only if it could satisfy a quote-unquote heightened standard of need, akin to the sort of showing one must make to get discovery of an adversary lawyer's work product, in my analysis. On the facts, the court held that the standard was not met, but that's not the central point. The central critical point is that the confidentiality agreement in case number 1 was in no way an absolute protection from discovery requests in case number 2 from someone who was not a party to case number 1. Again, big cause for concern for us in California. But then it got more complicated in New York because Magistrate Judge Fox issued another opinion in GE versus APR on December 20th, 2020. This was another motion to compel production of the same materials from the mediation in that prior related case to which APR was a party. While the motion was denied, it's a warning regarding mediation confidentiality. The court noted that in the prior mediation, the parties had a written confidentiality agreement, but that seems not to have made a difference to this court. And again, even though just 1 week before, District Judge Furman in Accent Delight had ruled that this type of discovery could be obtained only on meeting a quote-unquote heightened standard of need, Magistrate Judge Fox, in this opinion, makes no reference to the Accent Delight opinion, makes no reference to the heightened standard of need, and Magistrate Judge Fox simply seemed to apply the general standard of relevance under Federal Rule of Civil Procedure 26. This motion to compel production was nonetheless denied because the court had previously sustained APR's objections on grounds of attorney-client privilege and work product. So if you think you can promise someone that a New York court's going to respect California law or California mediation confidentiality agreements, it's a risky promise to make, and we'll talk about that in a few more minutes. Let me say, though, that as a policy matter, this is not entirely bad. As I mentioned before, courts are involved in a search for truth. We want people to have confidence in courts, confidence in the ability of courts to make decisions that are right. And every assertion of privilege frustrates the search for truth because it frustrates a trial court's ability to get relevant evidence presented to it or to a jury. So we have what's called the traditional Wigmore view of privilege from the Wigmore evidence treatise. Privileges are to be construed narrowly, no more broadly than necessary to achieve their goals. And so the fact that courts are struggling to get relevant evidence before them to decide matters correctly, not entirely bad. Now, let's take a look at mediation confidentiality agreements. You've signed them. They make absolute promises, airtight promises. Nothing said or done in this mediation will ever become the subject of discovery or introduced or offered to be introduced in evidence in this proceeding or any other proceeding, whether it's a trial, arbitration, administrative proceeding, or other proceeding of any type whatsoever, any place in California, anywhere else in the United States or in the known world, this universe, the Marvel superhero universe, or any other place. Now, mediators, you've probably put those out there. Lawyers, litigators, I believe many of you have signed them. Here's the problem for both mediators and litigators. This is not a promise that we have the power to keep. It is a promise that can be kept or broken only by judges in subsequent cases, or perhaps even in the same case as Mr. Hausinger found out. It can be kept or broken only by judges who are considering requests to compel the discovery of information from our mediations. What do I believe? Give it enough time and it will happen. Sooner or later, somebody else will be just as surprised as Charles Larson was in the 10th Circuit, or as Mr. Hausinger was in New York when he saw that appellate division opinion. If it is you, lawyers or mediators, who find people surprised when your promise of airtight confidentiality is broken by a judge, there may well be liability. The claim will be that whether you're a mediator or a lawyer, the claim will be that you induced or allowed your clients to be more candid than they otherwise would have been, and it came back to bite them. The claims will be perhaps negligent misrepresentation, perhaps ordinary negligence, maybe worse. In any case, nobody wants to be south of the V on one of those. There are potential ethical issues as well. We give ethics credit for this presentation. We have to talk about the ethical issues. One ethical issue is, as we all know, you're not supposed to make guarantees to anyone of the outcome of future judicial proceedings. And yet, when you make that airtight confidentiality promise to people, is that not exactly what you have done? Have you not promised or guaranteed to them that any judge, arbitrator, or anyone else considering a later request to compel production of material from your mediation is going to deny that request? I think in substance, that's exactly what you've done. You've guaranteed an outcome, and that's an ethical issue too. When we talk about ethical issues in more detail, we know what our major ethical obligations are: competence, communication, and candor. First, there's the question of competence. You have to advise your clients competently as to what confidentiality or privilege laws actually apply and what laws later judges may or may not apply to your mediation. There's the question of communication. You must communicate the law clearly to your clients so that your clients can make informed decisions as to just how candid they do or do not wish to be in mediations. And candor. You have to communicate honestly with your clients about the situations they face. And I believe that all three of these principal ethical issues that are implicated, there's problems with all of them when we make airtight confidentiality promises, whether we are serving as lawyer, as litigator, or as mediator in any particular case. Now, it's an interesting thing about these confidentiality agreements, because we've talked about potential problems when promises of confidentiality are breached. There are also problems, potential malpractice and ethical problems, when confidentiality agreements are enforced. Oh yes, And the leading case here is a Ninth Circuit case. It's called Facebook versus Connect You, Ninth Circuit case from 2011, written by Judge Kaczynski. And this is part of the saga of the battle between Mark Zuckerberg and the Winklevoss twins. Perhaps we saw that in the wonderful movie, The Social Network, a few years ago. Many of us know that Mark Zuckerberg bought the Winklevoss twins' shares in Facebook from them, and the Winklevoss twins felt that Zuckerberg defrauded them. So they sued Zuckerberg for securities fraud in the Northern District of California. They had a mediation in San Francisco, and they signed an airtight confidentiality agreement. They settled the case, but then the Winklevoss twins came to believe that Zuckerberg had defrauded them again, this time in connection with the negotiation of the settlement agreement at the mediation. So they applied to the district court to release them, to unwind the settlement agreement because of fraud and its inducement. And when the Ninth Circuit got a hold of this, they noted that under operation of law, if Federal Rule 408 had simply applied to this mediation, as it would have in the ordinary course, the Winklevoss twins would have been able to use the evidence of what happened in the mediation to support a contract-based defense for fraud to the enforcement of the mediated settlement agreement. Remember, Rule 408 prohibits the introduction of settlement negotiations only if used to prove the validity or lack of validity to the claim being negotiated. The Ninth Circuit saw, well, this is a collateral purpose, and ordinarily it would be permitted, but the parties signed that confidentiality agreement, and the confidentiality agreement was an airtight promise of confidentiality. So Judge Kaczynski, writing for the court, said that Zuckerberg twins, while you, under ordinary course, you would have been able to use this evidence, you cannot prosecute your claim or your defense to the enforcement of the settlement agreement because of this, what your lawyers had you signed before that mediation began. Here's how the malpractice risk in the Facebook situation appears to me. The legislature, whether Congress or the California legislature, intended your clients to have certain rights in connection with mediations. In Federal Rule of Evidence 408, Congress intended people to have access to mediation-related evidence to support contract-based defenses to the enforcement of mediated settlement agreements, fraud, duress, and mistake. But with an airtight confidentiality agreement, you may be forfeiting your client's rights that Congress or a state legislature intended your clients to have. Is that what you intend to do? And if it is, are you telling your clients that that's what you're doing when you have them sign an airtight confidentiality agreement? Again, the ethical duties, the duties of communication and candor clearly come into play when this is what you're doing. You have to advise your clients honestly. While it's highly unlikely, I acknowledge this, I know that in any particular case, the chance that a judge in a later case is going to strip away the confidentiality you thought you had in the mediation, I know the chance of that is quite low in any individual case, but it could happen. And given enough time and enough cases, I believe it almost certainly will happen again. Could happen to you, and so I advise you, behave accordingly. I know what some of you are thinking at this point. You're thinking, well, gosh, will this hamper mediation? Will people still come to mediation without these airtight confidentiality promises? I believe they absolutely will. Let's look at the real world. Let's look at New York. Plenty of mediation takes place in New York, where everyone knows that the protection of mediation confidentiality, both by statute and by contract, is very slight. Consider the real world in New York and its neighboring state, New Jersey. New Jersey, in contrast to New York, has the Uniform Mediation Act, which is a much more robust protection of the privileged nature of mediations. If mediation confidentiality were that important, you would think those bright and clever New Yorkers would go across the Hudson River to mediate their cases in New Jersey, but they don't. There's no evidence of a mediation tourism industry in New Jersey. I called the officers of the New Jersey Association of Professional Mediators, comparable to our Southern California Mediation Association. And I asked them if they marketed mediation tourism, if they marketed the mediation confidentiality and privilege statutes of New Jersey as a reason why people should come to New Jersey from New York to do their mediations. These people in New Jersey thought that was the craziest idea they've ever heard. No, of course they don't market mediation tourism, the benefits of the UMA. Look at the real world experience of JAMS. JAMS is an intensely profit-making organization, and good for them in the private economy of the United States. If you go to the JAMS website, you'll see that JAMS has a big office in New York City, swanky offices in the New York Times building on 8th Avenue. Beautiful suites of offices. I've been there, perhaps some of you have too. But there's no JAMS office in New Jersey. If JAMS thought that there was money to be made through mediation tourism, believe me, I think they would have done it by now. Interestingly, people do respond to the laws of New Jersey when they make a difference in other contexts. Jersey City, right across the river from Lower Manhattan. They've got big buildings, office towers, beautiful restaurants, a nice place. One of its benefits is that Jersey City has a 3.9% sales tax. In Manhattan, the sales tax is over 9%. Jersey City, I am told, has a thriving retail economy as a result. Now consider what happens in other states. It doesn't make a difference anywhere. Consider the experience of Ohio. Ohio has the Uniform Mediation Act, and its neighbors do not. Michigan does not. Toledo, Ohio, is right across the border from Michigan, just south of the Michigan-Ohio border. I gave this talk to the Ohio State Bar Association, and in my research, I asked whether there's any kind of mediation tourism industry in Toledo. They assured me there was not. Cincinnati, Ohio, is the southernmost point in Ohio, and it's just north of the Kentucky border. In fact, if you've ever been to the Cincinnati airport, it's in Kentucky. That's how close Cincinnati is integrated with Kentucky. Is there any evidence of a mediation tourism industry in Kentucky? In Kentucky and Ohio, do people come to Cincinnati to mediate their cases? No evidence of that. But when laws are designed to attract litigation activity, people do respond. Consider the experience of Texas. Some of you on the line may handle patent cases. Glenn, I know you mediate some patent cases. Well, if you're involved in the world of patent litigation, you've probably been involved with Judge Gilstrap in the Eastern District of Texas and Judge Albright in the Western District of Texas. That's because they have designed procedures specifically to appeal to patent litigants, to attract patent litigation to those venues. And you know what? It's worked. The last time I looked, some incredible number of patent cases, I think over 40% of all the patent cases in the country are pending with Judge Gilstrap and Judge Albright down in Texas because they've designed procedures to appeal to litigants and they work. People respond to laws that actually benefit them. What inferences can we draw from the fact that mediation confidentiality laws seem not to have that lure? Now, at the beginning of my talk, I mentioned that I have not used the so-called Mediation Confidentiality Agreement for many years. Some of you may wonder why. Well, first of all, Evidence Code 1115, ETSEC, our current mediation confidentiality statute, was enacted in 1997, effective 1998. It provides for all kinds of things in connection with mediation confidentiality. It includes a provision that we mediators get our attorney's fees if we successfully resist a subpoena. So before 1998, we needed lengthy confidentiality agreements that included all those sorts of things. For example, the attorney's fees protection in case anybody tried to subpoena us and we resisted. But after 1998, we didn't need all that stuff in our confidentiality agreements because it existed by operation of law. But there is one relic, one provision that seems to have survived, and it may well have been in the last so-called mediation confidentiality agreement you signed. And it's a statement that goes like this: the mediator shall have no liability for any act or omission in connection with this mediation. The mediator shall have no liability for any act or omission in connection with this mediation. It's a prospective waiver of liability. My friends, in my judgment, it's a cowardly act. I'll go farther than that. I believe it's immoral. And I'm going to ask every lawyer in this webinar never to sign one again. And I'm going to ask every mediator in this webinar, take responsibility, stand behind the quality of your work. It's why you have malpractice insurance. Get that out of your confidentiality agreement. What is a mediator really saying when they try to foist this prospective waiver of liability on you? What a mediator really says is this: in the unlikely event that I commit malpractice that causes you financial damage, and even though I carry malpractice insurance so that you can be compensated without causing me to suffer financial ruin, it is personally important to me that you do not receive compensation for the damage I have caused you. I've called it a cowardly act. I've gotten some pushback on that. Nobody has ever yet explained to me, though, why it is a courageous act to try to avoid responsibility for the consequences of your own conduct. Litigators, if you were to put a prospective waiver of liability in your engagement letter with your client, you could be subject to state bar discipline. It's right in the California Rules of Professional Responsibility, Rule 1.8.8. What does this liability waiver have to do with confidentiality? Nothing, but many mediators tuck it into a so-called confidentiality agreement. When we do that, as mediators, we demean ourselves. We're announcing to the world that we are lowering our ethical standards when we mediate. And you, as litigating lawyers, if you're a litigator, are accepting a mediator who is practicing at a lower ethical standard than your own. Litigators, you're also accepting services at a lower level of competence. A mediator who tries to be exempt from the tort system loses one motivation to perform services competently. The tort system is designed for many things. The most obvious reason is to provide remedies to people who are the victims of negligence and other tortious conduct. But it's also designed with a prospective and forward-looking purpose in mind as well, to ensure people that perform services competently and carefully as they go about their business every day. And that's because people know that there are tort consequences to suffer if they do not perform competently and carefully. If you remove one incentive to competent performance by mediators, the quality of service you will receive can only suffer. And we as mediators, we should want to inspire confidence in the quality of our work. We should send the message that we stand behind the quality of our work and that we want you who work with us to be compensated, treated fairly in the unlikely event that something goes wrong. I don't think any of us would accept prospective liability waivers in other contexts. Can you imagine being leaned back in the dentist's chair, and as the Novocaine starts to take effect, your jaw is being held open, the dentist says, Mr. Gottlieb, before I insert this electric drill inside your skull, just want to let you know that I shall have no liability for any act or omission in connection with this dental procedure. Glenn, I suspect you'd get out of that dentist's chair right away. And I suspect everybody else in this listening to this would as well. I know Glenn would be out of there. He'd be history, and I think everybody else would be too. Now, again, I've developed some telepathic powers because I've presented this webinar many times now around the country. And some of you are thinking, will you still be able to hire excellent mediators if you do not agree to the prospective liability waiver? And the answer is absolutely. Though we're all lawyers, I learned some lessons about law in my undergraduate economic days at Berkeley. And I wanted, at the risk of causing some of you tummy aches or even migraines, I'm going to give you two laws that I learned in economics, laws that you can never break. What are the two laws that you can never, ever break? supply and demand. And the truth is, there are more mediators, way more mediators on the supply side than there is demand for mediation. I'm going to go farther. There are more really good mediators than there is demand, especially now that you can hire mediators anywhere in the world because we're doing them all online. There are plenty of mediators out there, excellent mediators, who stand behind the quality of their work and won't foist a liability waiver on you. How do I know this? I've been giving this talk to mediators all over the country. Many very fine mediators have told me that they have been persuaded. As one very fine mediator in our own Los Angeles community told me, Jeff, you're right. We're not an endangered species. We're not a protected class. We are participants in the American economy, and we are not above the law. And that's that. And to the litigators who are listening on this call, just think about it. You have terrific work to give to mediators and plenty of it. You're the ones with the power in the negotiation. The demand side of the equation has the power. The supply side does not. If every lawyer on this case simply said no more to the liability waivers, they would be gone in a week. I want to leave some time for questions and answers. I have a call to action for you. But before my call to action, I have a request. I have shared some big ideas with you, and I'd love for you to share some of your big ideas with me. I teach mediators, train mediators all over the country, beginning levels, advanced levels, all of it. And I love doing it. A lot has changed in the last year now that we're doing it all online. And so I'd like to ask you, what have your experiences online taught you about mediation? And how does it change the way we teach and train mediators? What do we need to teach mediators differently now that we're in the online environment? What are new skills that mediators need to learn? What are dormant skills that we need to improve? And are there any old skills that we need to abandon or de-emphasize now that we're acting in the online environment? This is my email, jk@jeffkichaven.com. That's my cell phone, 310-721-5785. Please share your big ideas with me. I promise you it can only improve the way mediation services are offered to you and your clients. I'd appreciate any feedback people may have on how to improve mediation training as we go forward. So here's the call to action. Counsel your clients honestly about the fact that nobody can promise airtight confidentiality to their mediations. Strike those confidentiality promises from mediation confidentiality agreements. Number two, never sign off on a prospective waiver of liability in favor of a mediator. Because in our great country, nobody is above the law. And then ask yourself, do you need a so-called mediation confidentiality agreement at all? And you may, for several reasons. One, you may want to have something that says it is your intent that the privilege or confidentiality law of a particular state apply if you're involved in a multi-state mediation. Greater confidentiality may protect you, or lesser confidentiality may protect you. It's a case-by-case situation. Also, statutory mediation confidentiality does not apply to the questions of whether you can talk to your bartender or a reporter from the Los Angeles Times or other people about what happened in your mediation. And you may want to have those kinds of provisions in a confidentiality agreement, or you may not. There are many circumstances where those kinds of provisions are highly controversial. Products liability cases, sexual harassment cases in the Me Too era, other kinds of cases as well. You should approach mediation confidentiality agreements the way you approach any other kind of contract you would advise your client to sign, carefully and not thoughtfully, carefully, not reflexively. With that, my friends, we have about 10 minutes left for questions. Glenn, hopefully it's been sufficiently provocative that we won't get to all the questions. So if people have a question, I believe they deserve an answer. This was a lesson taught to me by the great Diane Karpman past president of the Beverly Hills Bar Association. And Diane said, always leave them with ways to get in touch with you, because if they have a question, they deserve an answer. So homage à Diane. There's my email and phone number again. And thank you all very much. It's great to be back in Beverly Hills. I really haven't lived here since 1973 when I graduated from high school, but I still really consider it my home. And whenever anybody asks me, Jeff, where are you from? I very proudly tell them, I'm from Beverly Hills. Glenn, back to you.
Jeff, thank you very much for a really, really outstanding presentation. As I indicated in my introduction, never hesitant to take a controversial position as you have today. And by the way, I forgot to mention in introducing the program that this program was put together by our program chair of the mediation section, Adam Porter, who was unfortunately not able to participate today due to some personal matters. So we wish Adam the best. And I want to thank you, Jeff, for now giving him his next idea for a program involving mediator liability for an MCLE program. And that actually involves one of the questions that was asked by a participant. Can you discuss mediator liability just briefly, and what would be an example, in your opinion, potential hypothetical of mediator malpractice?
Yeah, thanks, Glenn. I'm happy to talk about that. There are basically three ways a mediator can commit, three significant ways I think a mediator can commit malpractice. One is somebody can tell you something in confidence and you can inadvertently leak it to the other side, intentionally or inadvertently. So if somebody tells you something in confidence and you disclose it to the other side advertently or negligently, that's sort of by definition negligence. The second way is in drafting a settlement agreement. Let me be provocative once again. A lawyer who allows a mediator to hold the pen, touch the keyboard, is a fool. The responsibility for drafting a contract that fully protects your client's rights is your responsibility. And you should want, lawyers, you should want as much control over the drafting process as possible. The mediator does not share the same ethical obligations you have to your client. You are your client's champion, the one with the duty of undivided loyalty, a fiduciary obligation. In drafting settlement agreements, Glenn, you know, once or twice a year, there's something in the Daily Journal or one of the advance sheets with the title something along the line of the $1 million comma, where the inadvertent placing of a punctuation mark in some document or a settlement agreement ends up costing somebody $1 million or maybe more. Well, the proper placement of commas, use of punctuation, all of these things, they make a difference. And mediators, you know, it's been a long time since I took 7th grade English at Horace Mann School from the late, great Bernice Anfuso, one of the great teachers I've ever had at Horace Mann School in Beverly Hills. And back in 1968, when I took 7th grade English, I think I was pretty good at placement of commas, but I don't want to make any guarantees now. So it's easy to make a mistake in the drafting of a settlement agreement. And the lawyers should take responsibility for that to make sure that mistakes are not made and that settlement agreements fully protect their client's interests. And the third way that a mediator can commit malpractice is by improperly advising people as to the scope of the confidentiality or privilege rules that will apply to the mediation.
You know, just a comment on drafting the settlement agreement. It's interesting, the point you make as a, not just a former, but a current corporate lawyer. I will often take a hand in assisting the parties in drafting the memorandum of settlement, never the full settlement agreement, but I always, of course, have the lawyers examine it. I will note that when the ADR office of the Superior Court was still operating, they had forms that they provided to the lawyers. And at one point, the form changed because the heading on the form when it first came out was the caption of the mediator and who had participated as the mediator. And I think, I don't know how the change exactly came about, but a couple of years before the ADR office was disbanded, that changed, and the preferred form that was used had a caption so that one of the lawyers would put their name on it rather than the caption of the mediator. So as you say, the lawyer was taking the responsibility, at least publicly in that written format, for the content of the of that settlement memorandum. So it's a very good point. Let's see, what else do we have here? Another, well, this is really, I guess it's a follow-on. One participant asked, in light of the California case law that makes it practically impossible to sue a mediator or anyone else for malpractice when what happened in a mediation is relevant to the claim, does the removal of the no liability for the mediator provision really matter, at least if the case is strictly a California case?
Probably not. I mean, the mediation confidentiality statute de facto functions as an immunity statute for mediators, which I think is terrible. But that is the law.
Another participant asked, is there a confidentiality risk in a mediation of a dissolution of marriage matter with everyone in California?
Well, you know, Glenn, I'm not a family law mediator or expert, and so I think I am best advised, reminded of Benjamin Franklin's statement, best to keep your mouth shut and be thought a fool, and open your mouth and remove all doubt. So I'm going to leave the family law issues to the family law experts.
Fair enough. I would say, actually, I've done some, those in the audience are family mediators and know the name of Woody Mostyn, who I know that Jeff knows very well, both of us professionally as well as personally, another nationally and indeed internationally renowned mediator who primarily operates in the family field. And so I've done actually a little bit of family mediation. And interestingly, just in the way family mediations are conducted, normally they're conducted virtually entirely in joint session. There are almost no caucuses, and the participants, whether with lawyers or not with lawyers, are all together in the same room. And so there's a little different question of confidentiality, because not much is going to be said in a joint session that would expect it to be confidential, because you're right there with all the parties in the room all at the same time. So that is an interesting question. Also, in family law matters, there's the slight hybrid procedure in collaborative law, which again involves not only really joint sessions, but also the parties engaging singular participants, like one accountant, one child representative type of thing. And so the parties have obviously waived confidentiality as far as that goes, because they're using one joint person rather than both hiring for matters of cost. So that there are differences clearly procedurally in the family law area that come into play. Somebody says, Joanne Ratnoff, who is a member of our executive committee of the mediation section. Thank you, Joanne. She says, I think we ought to have a separate program for mediation confidentiality for family law matters, especially as it may relate to prenups and governing law cases. So Adam, if you're on this call, or if you're not, I'll mention it to you later. I think that's an excellent point, because as we say, family law is an entirely different matter. With that, we are hitting our deadline for 1:30, right on the money. Jeff, again, want to thank you on behalf of both the mediation section and the litigation section for an outstanding presentation. I always appreciate it, and I always appreciate your thoughtful approach to moving the ball forward and presenting controversial issues for us to all think about. So thank you all very much for participating. Again, just a reminder, you should be getting your MCLE certificate for this within the next 24 hours. If you do not get an email to that effect, after checking your spam folder to make sure that it didn't get redirected there, please contact the Beverly Hills Bar Association.
Glenn, thank you so much. Thanks to everybody who took time out of their busy day to listen to this webinar. I greatly appreciate that. Thanks so much to the Beverly Hills Bar, Belinda McCauley, to Adam Porter, prayers with him and his family. Glenn, thank you very much. This been just wonderful. Thank you, Beverly Hills.
Everybody take care, stay safe, and get your shots. Be well.